In this short video, we'll talk about a few tips for reducing verbal clutter in your legal writing. We're going to go through 5 quick tips for reducing that clutter. Some of these might require a bit more digging if you're not familiar with the concepts, but this video will, I hope, give you a starting point for your editing. We'll talk about checking your verbs, looking for clusters of little words, particularly the word of, avoiding expletive construction, checking for compound construction, and looking for repetition. So first, check your verbs. The first tool is looking for the passive voice and nominalizations. Remember, in the passive voice, the sentence's subject has been obfuscated. So here you need to look for the subject in the sentence. Is it missing, or is it relegated to the back? The first sentence is in the passive voice. It has been decided that a work's commercial purpose is weighed against fair use. Note there are 2 instances of the passive voice here. It has been decided and is weighed. In both cases, the subjects of those verbs are missing, the decider and the weigher. So make them active. Put the subject back in. In this case, the court is deciding and the court is weighing. So revising it to the active yields a clearer sentence. The court decided it will weigh a work's commercial purpose against fair use. Here's an alternative revision. Courts weigh a work's commercial purpose against fair use. Now this one depends upon the writer's intent. In the first revision, the writer chose to point out that the court was making this decision, right? In the second one, the writer is stating it more as a rule. The passive voice and nominalizations, just as a reminder, aren't grammatically incorrect constructions, but they do tend to yield cluttered sentences because the construction takes more little glue words. This might be a place where you need to dig in a little further. Read chapter 3.4 Beyond the First Draft, or refer to another video if the concepts of passive voice and nominalizations aren't so clear. Remember, a nominalization occurs when a verb or an adjective is converted into a noun. One quick tip for looking for nominalizations is to look with words that end with tion or ion and ment, but that's not always the case. Some of those nominalizations look a little different. Here's an example of 2 nominalizations that can be converted back into verbs. The FHA requires that a landlord make an accommodation for a person with a disability when it will not create an undue burden. Accommodation here is a nominalization, and in order to use it as a noun, the writer has to say, make an accommodation. The original verb, accommodate, would be more concise. Burden here is also being used as a noun. Here the writer has to create a wordy phrase around it in order to use it as a noun. If converted back into a verb, it's more concise. The FHA requires a landlord to accommodate a person's disability when it will not unduly burden the landlord. So here, converting the nominalized words back into verbs yields a more concise and straightforward sentence. Look for verb tense too. The unnecessary progressive tense, whether present or past, can just add extra words that don't need to be there. The progressive tense is supposed to describe action that is currently happening at this moment. In the past progressive tense, it describes action that was happening when another action interrupted it. They're not actually interchangeable with the present simple or the past simple tenses, though they sometimes get used as if they were. And this construction happens to be a bit wordier anyway, at least by 1 word, but every word counts. So here, this first replacement switches the verb tense. The court was deciding. That's the past progressive. Just say the court decided. It's shorter by 1 word. In the second one, the appellant is arguing. That's the present progressive, but really it should be the present simple. So reducing it and correcting the verb tense eliminates 1 word. Here you can see that I've made a revision that eliminates the appellant is arguing altogether. So take a look at these 3 sentences. The appellant is arguing that the accommodation was reasonable. That can be converted to the present simple. The appellant argues that the accommodation was reasonable, a little bit more concise. But that intro can get cut off altogether if the writer just wants to make the punchy point that the accommodation was reasonable. Get rid of all of that hedging behind the appellant and just make the point. Subbing in the right verb tense makes the sentences shorter, and it usually replaces the verb with a more interesting verb than is or was. The next tip is to find clusters of little words. I'm going to recommend that you start by looking for the word of. Of can sometimes be deleted altogether as clutter, or it can be replaced with possessives, adjectives, or adverbs in order to make more concise sentences. So in each of these examples, the of can be removed and improved. His attorney advised him of the fact that his claim was without merit. In this case, the of yields just filler, of the fact that. That can be deleted wholesale. His attorney advised him that his claim was without merit. That is pure surplus. The second one can eliminate the of in the first instance, but I chose not to reduce it in the second one. The first of showed possession, right? We're really talking about a corporation's directors. So it can be replaced with just the possessive form of corporation, right? An apostrophe S. Here the duty of loyalty isn't revised because calling it a loyalty duty would be uncommon in legal writing. So I've preserved that key term. So of should be a red flag for you, but not an automatic delete. In this next example, the of is used to introduce an adjective or arguably to show possession. It's either describing the criminal code as Californian, right, adjectively, as opposed to Iowan or Georgian, but one could also say it's possessive, right? This criminal code belongs to California. Either way, it can be eliminated. The Oregon Criminal Code mirrors the California Criminal Code. Here, it's using California as an adjective. Or the Oregon Criminal Code mirrors California's Criminal Code, turning it into a possessive. The next tip is to remove expletive construction. Expletive construction is when it is, or there are, there is, there were, it was, those forms clutter up a sentence. When they don't point to anything in particular. You can't tell me what's behind the it sometimes, right? And when you find expletive construction, you can replace it with concrete nouns and specific verbs. Here are some examples. There are recent decisions that have made clear the rule that the commercial character of a work does not automatically preclude a claim to fair use. There are isn't really doing anything here, and it can be rearranged. Here's another example of just verbal bloat. It is worth mentioning that many listeners misunderstand the message of Bruce Springsteen's Born in the USA. Think for a second about how you might fix these. Just take it out, right? So recent decisions clarified the rule. Or, depending on the context, stated as a rule. A work's commercial character does not automatically preclude a fair use claim. This one can be deleted by just taking out that bloat at the outset. Just take it out and say many listeners misunderstand the message. The second one, this it is worth mentioning, is an example of expletive construction, but it's also just throat clearing. Just mention it instead of prefacing it with a warning that you're about to say something interesting. The next tip is to look for compound construction. Compound construction occurs when 3 or 4 words do the work of 1 or 2. So these are all examples of compound construction, the question as to whether, as opposed to just whether. Or whether or not. You could just say whether. It implies the not. Is authorized to. Aren't we really just saying can or may? In order to could just be to, and will be able to can just be can, right? So all those little wordy phrases that use 3 or 4 words where 1 or 2 would do. If you want a more complete list of these compound constructions that are pretty common in legal writing, you might look in Chapter 310 of Beyond the First Draft, or in Chapter 2 of a book called Plain English for Lawyers by Richard Wydick. You could also Google common wordy phrases and find a pretty exhaustive list on a number of websites. So why bother with all this editing? That's because shorter sentences pack a bigger punch. Here's an example of a couple of conclusions. The first one is really long. In this case, based on the evidence in the record, a jury could not have concluded that the accommodation was reasonable and necessary, and therefore summary judgment was appropriate. If the writer's really trying to make an impact with its conclusion, this first sentence doesn't do it so well. The revision is better. This court should affirm summary judgment. A court could not find the accommodation reasonable or necessary. Sometimes loading a sentence up with modifiers and intros can muddle it. The meaning is hiding. A short, direct sentence can make more of an impact. You might consider getting straight to the point with a shorter sentence, like the second example does, and writing a follow-up sentence that contains necessary details that refine or explain that first one. Here's another example. Pendleton College discriminated against Jacob Staten because it refused to provide him with an accommodation that was reasonable and necessary in light of Jacob's disability as required by the Fair Housing Act. That is very thorough, but it's kind of hard to keep track of all the ideas happening in that sentence. The next example, the revised version, is punchier. The conclusion is clearer. Pendleton College discriminated against Jacob Staten. If that's the point the writer wants to come through to the reader, they should state it directly and more concisely. The second sentence follows up with some of that refining information. It discriminated against him by refusing to accommodate his disability as required by the Fair Housing Act. Note that second sentence serves as a substantive transition that first part does. It discriminated against him by refers back to the old information from the first sentence and introduces the new information about how it discriminated against him. It gives the writer two opportunities to say that Pendleton College discriminated against Jacob, right? Pendleton College discriminated, it discriminated against him. That has a real persuasive effect. You also want to check your writing for repetition. This is harder to root out with a Control-F trick. It's just about looking at every sentence and figuring out whether it needs to be there or whether it's saying something you've already said. That's the hard work of revising. You need to assess every sentence one by one to determine what its function is. Does every sentence move the analysis forward? It should. Everything in a discussion section ought to be progressing the reader towards your point. Where you find repetition, does it serve an important purpose? So for example, in a CREAC, there's a conclusion at the outset and a conclusion at the end. That's repetition, but it's repetition that serves an important point. The first to give the reader context and the second to tie the conclusion together for the reader. So that repetition serves an important purpose. Other repetition just says things twice, adds bloat, and muddles the analysis. These aren't the only ways to reduce verbal clutter in your writing, but they'll give you a starting point. If you need more information about any of the things we've talked about here, check Beyond the First Draft for more specifics and more examples.